All right, we can start, CJ.
All right, I'll go ahead and repeat for the record. The Supreme Court of Guam is now in session. We had some technical issues. So for the record, we will just repeat the introduction. Will the clerk please call the case? All right, we seem to be having some technical issues. The case has already been called and it's been recorded. So we'll just go ahead and proceed with Mr. Highsmith. You may begin your arguments, Mr. Highsmith.
I can, if the Chief Justice likes it, the case is People versus Yerten, CRA 19-018, appearing on behalf of Mr. Yerten is Attorney David Highsmith, and appearing on behalf of the people is Attorney Christine Tenorio.
All right. So thank you, Justice Torres. Mr. Highsmith, for the third time, let's try again. You are recognized.
Good afternoon. Thank you, Mr. Chief Justice. May it please the court. There are two issues in this case. First of all, there's the denial of the court of the defendant's motion to suppress, which was based solely on the late filing of that motion. And secondly, there is the motion to suppress itself, which was never exactly heard by the court, but the facts of which were developed at trial. We believe that it was an abuse of discretion for the trial court to decline to hear the motion to suppress. The motion was clearly not frivolous. It had substantial factual and legal a legal basis in the Terry stop law of motor vehicle stops. The facts developed at trial supported the motion. It would not have delayed the trial or the proceedings in any way to hear the motion. There was no evident prejudice to the prosecution, and it was a constitutional issue. So,
Mr. Highsmith, if we could just revisit your arguments in reference to you're asserting that it was an abuse of the trial court's discretion not to hear the motion to suppress. You seem to be conflating the continuance of the trial with the motion to suppress, the denial of the motion to suppress. And in that particular case, let's keep them separate for purposes of this discussion. There clearly is a rule that the judge had set the date to file the motion, and the motion was not to suppress, was not filed by the date set by the trial court in terms of the due date. And there are a rule of court, CR 1.1F, that if for whatever reason the lawyer is not able to meet that deadline, there needs to be a proper motion for an extension and good cause provided. So how did the trial court abuse its discretion when no cause was provided for the late filing?
Well, as I have said, there are some problems with the record here. But as I say, the court obviously had the discretion to hear it. Had it chosen to do so, the Trong case makes it clear that such a motion can be heard even when it's untimely filed. As I said, there was no harm to the proceedings, no delay, no prejudice to the prosecution, and it was a constitutional issue. That's really about all I can say on that matter, Your Honor.
Yeah, but let me just follow up one. Up to this time, in reference to you appearing in oral arguments, there's never been an explanation as to the cause for the late filing not meeting the deadline for filing the motion to suppress. So I'm having a difficult time determining how the trial judge abused his discretion when there was no cause advance by the public defender for filing the motion untimely up to this point.
True enough, Your Honor. All I can say is that there were no factors weighing against it, as I've said, and it was simply negligence. Obviously, either the assistant PD lost track of the deadline or thought it would be all right to file it late. Either of which would just be negligence. I can't add anything there.
Yeah, the public defender did not file a reply brief, so we didn't have the benefit of your response to the people's argument. And this is sort of as a follow-up to the Chief Justice's question, that because you failed to establish good cause or even assert any cause for why the motion wasn't timely, or assert prejudice resulting from the failure to hear the motion, and even failed to even do that in this appeal, that we should decline to hear the merits of your Fourth Amendment argument. And so that's the people's position in their response brief, their opposition brief. We didn't have a reply brief from PD. So I'd like you to address that issue, where the failure to establish good cause and prejudice, even on this appeal, that we should therefore then decline to hear the merits of the appeal itself.
Well, the facts behind the motion are laid out. The evidence at trial corroborated the facts alleged in the motion to suppress. The court perhaps has another option here. It could remand to the trial court with instructions to hear the motion to suppress, even without reversing the conviction. I cannot just make something up out of thin air and tell the court why it was not timely filed. So, but I suggest that there was a substantive argument to be made here, and it should have been heard. And it was the defendant who suffered as a result of whatever happened, Your Honor. So I can't add anything.
Let me ask one more follow-up question on that. In an earlier case, we had held that it's People versus White, that if the trial court excuses a waiver of a waiver under 65.45, which is basically that the failure to raise these objections or defenses at the time set by the court, that if the trial court fails to or excuses the waiver without a finding or showing of cause, that the court itself will commit legal error. And so you kind of put the trial court in a difficult position when you failed to show cause, because if they had granted the relief that you requested, which was to have the suppression hearing, even without any showing of good cause, following our precedent in People versus White, that they could have then committed clear legal error. So it seemed like they were in a bind. You had to show cause, or they were not permitted, at least under the holding in People versus White, that without good cause, that's clear legal error, and they can't excuse the waiver because of the way the statute reads. If you look at 65.45, it says the court for cause shown may grant relief from the waiver. So it's a statutory requirement that cause be shown.
I can't add anything to what I've already said, Your Honor.
All right.
Moving on to the merits of the motion itself.
You do that, Mr. Heisman. During the trial, didn't the court rule in essence on the motion to suppress by allowing the testimony from the police officer?
I'm sorry, Your Honor. Could you repeat that, please?
Didn't the court at trial, in essence, rule on the motion to suppress when it allowed the police officer to testify over objection of the public defender?
I can't say that that's evident in the record. I don't recall anything quite like that in the record, Your Honor.
Okay.
Did you want to add anything else?
Your Honor, about the motion itself, the only thing the police had was a conclusory allegation of drunk driving. There were no facts alleged. The law requires a prediction of future behavior to have reasonable suspicion for a stop. The police work must, independent police work must corroborate a possible violation of law before there can be a Terry stop. And the policeman must have objective grounds based on a totality of the circumstances before he can make such a stop. We believe this is plain error, that this was more in the nature of a forfeiture than a waiver, and that it can be analyzed on grounds of negligence, therefore, and that the motion should have been heard.
Mr. Highsmith, going to the merits of the motion, one of the requirements is that the police do some independent work to corroborate the anonymous tip. Didn't the police officer follow the driver? And then when he pulled the driver over, he didn't follow the directions he was given. Isn't that sufficient to create the probable cause of continuing illegal or future illegal conduct?
I understand the argument. I think that the reasons he didn't pull over were never sufficiently established. There was no interrogation, I believe, of the suspect, no field sobriety test, and he did pull over fairly quickly. I mean, he did pull over eventually. It just wasn't immediate. That's all, Your Honor.
Thank you.
Let me ask about, because you suggested that the tip, the anonymous tip, did not have an indicia of reliability. But in this case, the tipster was alleging, or specifically alleged, that there was criminal conduct, a drunk driver. They gave a description of the car, the plate, the direction of the vehicle, where it was traveling. And so I think distinguishing that from another case in which we held that where the tipster just reported a general conduct without alleging criminal conduct, here I think it's a little bit different because of the allegation that they were driving drunk. So it seemed like they gave, even though anonymous, some information that appeared to be reliable. And then, as Justice Merriman pointed out, the officer located the vehicle, activated his lights, and sirens and followed him, and he didn't pull over right away. And in fact, he saw him disobey a red light, at least according to the officer's testimony. So I have a difficult time understanding why there wasn't a basis for the stop.
Well, I don't have anything more to say, Your Honor.
All right, thank you.
Ms.
And
Santos.
I'll, if I may, I'll reserve the rest of my time.
Ms. Santos Tenorio, you are recognized.
Thank you, Mr. Chief Justice, and may it please the court. This is a case where the defendant appellant was convicted of driving under the influence as a misdemeanor. This was based on a traffic stop based on an anonymous tip coupled with the police officer's observations of the traffic violations that led to the stop. The suppression motion that the defendant appellant attempts to have this court hear at this time was initially brought up 6 days prior to trial. The trial court denied the motion, specifically finding that there was no good cause stated. Now, if your honors look at the additional transcript that was ordered after the submission of our briefings, the transcript shows exactly why. The trial court stated that there was no good cause because the defense counsel had been the same from the beginning, and they had notice of this traffic stop from the beginning. A closer look at the transcript shows defense counsel just repeatedly said that it was his fault and he did not have a good reason. He alluded to some fact where he didn't know the name of the defendant that he was representing to file the motion, but he did repeatedly say that it was his fault and that he had no good reason. That was part of the trial court's decision to then deny the motion as untimely. It is the people's position that the denial of the motion as untimely is a waiver under 8 GCA 65.45. And the reason this is distinguished from People v. Chong, where this court ruled that this is a failure to bring a suppression motion is subject to forfeiture rather than waiver. This case is different, and the reason why is because there was a specific finding from the court that there was no good cause. And I think that any holding by this court actually would expand on People v. Chong. As noted in my brief, in United States v. Johnson, 415 F 3rd 228, the Seventh Circuit has actually stated that the antecedent question before you get to any plain error standard of review, considering a forfeiture of rights, is that good cause has to be shown on appeal. And as Justice Merriman had pointed out, up to this time, there is no good cause on the record on the appellate level or trial level as to why this suppression motion got filed late. So given the standard abuse of discretion, the trial court did not abuse its discretion by denying the motion as untimely. Any abuse of discretion standard is based on going against all logic and just including not putting your reasons on the record. When the trial court made this,
Mr. Tenorio, I mean, the court had between April and the trial didn't start until September the 30th. So it had almost 4 months, 5 months. And in light of, the importance of a suppression hearing in this case, why couldn't the court have just, decided to go forward with it? I mean, I could understand continuing the trial date on April 9th and the filing of the motion so close to the trial date and vacating it and saying, no, because I'm not going to grant the motion because there's no good cause and we're on the eve of trial. But then the court sua sponte had 3 continuances of the trial date. And recognizing that, shouldn't the court have shown some initiative to then revisit whether or not it could have had the suppression hearing?
Your Honor, and this is where the motion to continue trial does become conflated. This is what the trial court, the record showed. It's that the initial trial was vacated so that the trial court could issue a decision and order on the suppression issue, because under the statute, the trial court still had to put the position in writing, because he did still have to either find good cause or not. Now, as far as the continuances, part of the government's argument is that the record is not developed as to the lack of good cause for continuance of trial. Now, the thing about this is that I went back, and the court, I think, could take judicial notice of this. I actually went back to look at the trial court's calendar. The trial court's docket, they had a trial every 3 weeks after this this trial was vacated. So I think that the issue is, and the whole rationale, as stated in my brief, of complying with deadline requirements is that there are trials docketed and everything has to get pushed back when somebody files something untimely. So I actually looked in the continuance for the 3 dates. There was trials going on in that same courtroom for those dates. Now, and this also goes to the point where Justice Merriman had made earlier. The trial court actually technically did rule on the suppression issue. And I stated that in the transcript, what had happened was the defense counsel renewed his objection to the suppression or the officer's testimony and during the actual trial. And then the issue came up again where the prosecutor said it's untimely, we can't hear that right now, but the court actually made a finding. The trial court made a finding on the record. It was that day, October 3rd, 2019, the trial, and said, your objection to this officer's statement is overruled because the anonymous tip contained the crime of driving while intoxicated. That's actually what the trial court stated. So in essence, it was heard, but as far as the continuance of the trial, it was there was good cause. If we go back to the record, that's not something that the appellant had brought up in their trial brief or had responded to, but that is what the trial docket looked like in that court. So again, going back to the waiver, the people's position is that the appellate review is precluded because when you do not comply with the timeliness requirements, you are precluded from taking that up on appeal. And the Seventh Circuit has made very clear, analogizing, because this is based on Rule 12B. It was the analogous rule to the our statute 8 GC 65.45. Exceptions for timeliness are the exceptions. It's an exception to the rule and should not be the relief from the waiver should not be granted because the timeliness requirements. Now, I also want to add that the trial court did also say that the time standards was what was keeping him confined to the motion deadline, but he still did find it issued a decision order on that matter. Now, going on to the if this court decides that appellate review is not precluded because this is akin to a forfeiture, the people will then turn to the merits of the Fourth Amendment violation alleged by the defendant appellant. The people submitted there is reasonable suspicion for this traffic stop based on even the anonymous tip alone, while this court has made clear in Mancipit that if the anonymous tip has an indicia of reliability where there is a crime being alleged and there's sufficient information given by the anonymous tipster that would indicate that this is reliable, warranting a stop, then the traffic stop, any police officer would have reasonable suspicion. In this case, the tip was specifically that the driver of this make and model of a car was drunk driving. Now, it is important to note that the officer didn't even stop the defendant at that point. He did activate his sirens, but the defendant did not comply. And then the officer observed him run a red light. The court has also held that when a police officer observes any type of a violation of a crime or traffic violation that is also reasonable suspicion for a stop. So we have the two reasonable suspicion based on two different things. One is the tipster's personal observations, and the other one is the police officer's personal observations. And the United States Supreme Court has said this is sufficient. When you look at the anonymous tipster's personal observation, specificity of the vehicle, contemporaneous reporting, and the use of 911 phone calls alleging a criminal activity, then that does have, that would give an officer reasonable suspicion for the stop. So I actually think that the rule is that the officer wouldn't have even needed to observe for himself the disobeying the red light. There was already reasonable suspicion based on the anonymous tip. And if the your honors hear this as a forfeiture under under the plain error standard of review, there was no error in this case. And if for some reason there's error, that is not, any error was not clear under Guam law, because under People v. Mansipit, that is distinguishable, or this case is distinguishable, and so it is under People v. Johnson. And here's why. In People v. Mansipit, this court overturned the conviction based on the stop, or upheld the suppression, because all the anonymous tipster did was say, there is a person with weapons, and that was it. Now, possessing weapons is not in and of itself a illegal criminal activity. Drunk driving is. So this is distinguished from Mansipit. This is also distinguished from Johnson, because in that case, there was a person who did not want to give their name because they were also going to be subject to criminal liability, saying that some guy in this car tried to sell me a plate. This is, again, different from that, because we have the reliability of the tip, which is what is distinguished. So under the plain error standard review, the people submit that this conviction for DUI as a misdemeanor should be affirmed, because there was no violation of any Fourth Amendment right of the defendant appellant, but also the people foremost want to say that the argument should be precluded. And this would actually, in contrary, if this court holds anything to the contrary, then any person, any defendant who fails to meet the timeliness requirements of a suppression motion, or even fails to just doesn't even think about making a suppression motion, it then grants this court it would be putting the onus on this court to decide every potential suppression motion at the appellate level when it was not considered down below. Thank you, Your Honors.
Thank you, Ms. Santos Genario. Mr. Highsmith, you reserve time on your rebuttal.
Yes, just a couple of things. I will point out, if I understand correctly, I believe the rulings about the suppression issue that were made at trial are at ER 91 and ER 110. It's a little confusing from the record, because the motion to the suppression issue seems to have been conflated with the motion to acquit that is typically made at the close of the government's case. At the initial statement by the court, he just said the motion is denied. Later on at ER 110, he said something about ruling it was justifiable, but once again, it's not very complete. Yes, the court could have heard the motion. As we have said before, there was no delay to the proceedings because it was filed late. And when the defense lawyer says, I had no good reason not to file timely, that's just a confession of negligence, that he didn't get it done. It seems like it fell between the cracks here. So if he had stated things a little more formally, like this was excusable neglect or something, perhaps the extension would have been granted. But he took responsibility for it, said it was his fault. Once again, the court could have heard the motion in time for the trial to go forward. The whole trial only lasted
But
a day or
Mr.
less than a
Heitz,
day here.
yeah, on looking at that transcript on page 110, I mean, it seems to support what Justice Merriman had pointed out. The trial court said the stop was ruled justifiable and legal under the ruling of this court. So it made that ruling on the stop itself. So, I mean, the idea that, and that's on page 110,
Yes, Your Honor.
on line 16 to 18.
Yes, Your Honor. I think if we look at the context, he's telling Mr. Or the defense lawyer there at that point that he can't argue anything about the stop on appeal.
No, he can't.
He doesn't
can't
say which
prevent
ruling of the
any
court he's talking
information from the stop coming into evidence because it was a valid stop. I mean, obviously the judge isn't going to be talking about the appeal issue here. He said he made a ruling on the motion and it's justifiable. That's up at pages 8 through 10. And then, Judge, I object to that. He said, whether you can, but you can appeal it. But the bottom line is I've made a ruling and I ruled that the stop was justifiable. So, I mean, he's not saying that anything else but the fact that his prior ruling, so he actually evaluated even when the officer was initially testifying whether the stop was a valid stop.
Yes, Your Honor. I think the court will just have to look at that and interpret it. I don't have anything further, Your Honor.
All right.
Thank you.
Any other questions?
No, thank you.
All right. Thank you, counsels. This case is taken under submission and the court stands adjourned.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.